Welcome to Dorsey and Whitney's webinar on coronavirus and contract performance featuring Shevon, Rockett, and Dan Brown, partners in Dorsey's commercial litigation group. I would now like to turn the call over to Dan Brown.
Well, good afternoon, everyone. Thank you so much for taking the time to join us. I'm Dan Brown. I'm a partner here at Dorsey in Minneapolis and a member of our commercial litigation practice group here. And when I have an opportunity to specialize, I actually specialize in agricultural biotechnology and insurance issues. But actually I also have the fortune of being able to still be a pretty general litigator involving a lot of contract disputes. I've got a couple of housekeeping items just to make sure everyone's keeping these in mind as we go here real quick. First of all, if you are going to sign in for CLE credit on this, we'd like to have you sign in those sheets and return those using the instructions. You will have an opportunity to submit questions. Those will be submitted by email, and then we'll be responding to those after the webinar. This is going to be a 60-minute program. We're hoping to stay right at about 60 minutes, so we may run over just a little bit, but hopefully you'll have an opportunity to stick with us. And we will, from time to time in this program, be asking a few sort of poll questions, just things to sort of get people's temperature and maybe keep people engaged a little bit. So hopefully that will help in this program. I do want to make sure that I introduce as well, and I'm really pleased to introduce Shevon Rockett. And Shevon, maybe you could tell us about yourself too.
Thanks, Dan. Again, my name is Shevon Rockett. I am in Dorsey & Whitney's New York office. I work primarily in the commercial litigation and product liability litigation group. Although I am in the New York office, I actually live in Philadelphia, so I cover a lot of the firm's Philadelphia-based litigation as well. And with that, we'll jump right in with the agenda for this next hour. We have a lot to cover. I'm sure you guys are anxious to hear the various avenues that things are starting to move with respect to contract performance and coronavirus. We're going to start with a discussion of the current state of play with respect to market disruption and what to expect, what is forecast for coming around the corner, and what exactly the parameters are to constitute market disruption. We're also going to talk about sources of force majeure, and we'll explain shortly why that is in quotation marks. Next, we'll turn to a topic that is of particular interest for those of you that have partners either upstream or downstream in China and have contracts governed by Chinese law, and looking at the Chinese Council for the Promotion of International Trade's Force Majeure Certificate, which is a relatively new occurrence. And then finally, we will turn to the case studies that discuss a lot of the topics that we're going to cover today. Along the way, we will provide you with practice tips so that you can consider really what's best for your business.
All right. Well, thank you. So we'll get started with just a little bit of discussion of what we're talking about with market disruption as it relates to force majeure. I do want to say as we get started that Shevon and I both recognize, of course, that the coronavirus outbreaks that have been occurring and that we've been hearing about in the news have impacts, obviously, on a human scale as well, and that obviously our hearts do go out to everyone who's being affected by those. I think we have the good fortune as we sit here in our offices to be talking about things like business issues like market disruption, and so that will be our conversation today. But we didn't want to start without at least acknowledging that we have that fortune to be thinking about this from a business perspective. With that, I will say that I was looking at a recent article from the Harvard Business Review. They are estimating that supply chain disruptions are going to peak in about mid-March, so whatever's been happening so far isn't done yet. And I suspect that's just a prediction right now as to how things are going to develop. So this is going to be an ongoing issue. And disruptions obviously can be some very direct things for folks' businesses, whether it's government-enforced regulations or quarantines or border closures or stoppages. It can be really specific things like supply chain shortages that occur for your businesses when it's goods or if it's services that are not being provided to you. And then, of course, another one that we'll be talking about a little bit is what happens when you've got local outbreaks that affect your labor force or others' labor forces. And then in addition to that, of course, disruptions can be indirect, whether it be downstream effects from some of those direct causes that we just talked about, or whether it's other things like reduced demand, like having a contract where you no longer need to provide what it is you would be providing under that contract. And it can be even other economic impacts like disproportionate pricing increases of your supplies, even if they're still available, or disproportionate pricing increases of those services. Obviously, there's going to be certain industries that are going to be most uniquely affected if it's travel or if it's medical. Almost every industry is going to be affected in some fashion by market disruptions, and we anticipate suffering some amount of disruptions either to supply or demand. So what we're going to be talking about today really relates to a couple of key questions. The first of which is sort of the most obvious. What happens if I can no longer perform on my contract? What doctrines will help me in that fashion? And of course, the reverse is also true. What if someone calls me and tells me they can't perform on the contract they have with me? What doctrines are we going to be looking at for those things? There's another question, which is what happens if I don't need or I don't want the performance because even though it could be provided to me, I have nowhere to put the goods or I have nowhere to provide those services, and I don't want to pay for those at this point. And then in addition, we do want to be focusing on, as is not uncommon in our industries, what happens if I'm in the middle? What if I've got a vendor on one end and I've got a customer on the other end, and one or the other is telling me that they either don't need the good or service or they can't provide the good or service? And the short answer is, well, will COVID-19 provide a basis to excuse contract performance under force majeure?
And so at Dorsey, we like to front load the value we give to our clients and our partners, and we understand that some of you may not be able to join us for the entire program. So we're actually going to begin with the end. And if you only have 10 minutes or so to listen, here are the top 12 things that you can do to better guard against contract performance risks. And the first thing is before performance is interrupted, as in right now, assess and document COVID-19's impact on your ability to perform obligations under your contract. And now really is the time to start looking at that, and we'll begin to illuminate that issue further when we discuss the cases. But as you'll see, the court is more likely to favor your position if you begin looking now and start documenting the important facts. The next thing is to retain counsel or ask in-house counsel to review relevant contract force majeure provisions. Again, now really is the time to do that. I know for most of us, either it's a boilerplate provision that you look at every single time you see your standard contracts and sort of gloss over, or for some of us, it may be a doctrine that you haven't thought about since law school, so now really is the time to look at the relevant provisions. Along with that, you should consider revising your standard contracts to include a detailed force majeure clause that anticipates labor and shortage of supplies that are related to disease or epidemic. We do have there listed also act of God, but we'll certainly we'll provide a little bit more color to that as well moving forward. The fourth one would be to consider drafting notice letters now if you anticipate a delay or disrupted performance.
And I'll chime in on that one for just a moment to say as well, we're not necessarily suggesting that you're going to be sending those notice letters right now, but we think that just the discipline of looking at what those notice letters might or should say is going to give you a head start at looking at your contracts and thinking about how that would work for the contracts that are most important and key to you.
And then also you should consider amending the current contracts to explicitly outline notice requirements and triggering events. Also keep detailed centralized records related to non-performance and potential non-performance. And again, that's something that we'll go into more detail later. The next thing is for specifically for the folks that have contracts or have partners either upstream or downstream in China, and there may be contract provisions that are governed by Chinese law. Earlier, I discussed the CCPIT, and we'll discuss it in further detail later. But if you're not able to fully enjoy that portion of the program for one reason or another, now you should know that CCPIT is a Chinese national organization that promotes labor and trade. And they're now, as of 2 months ago, issuing certificates that basically will show or prove in some respect that you had a factual and grounds for non-performance or delayed performance under China's force majeure doctrines. The next thing is attempt to use force majeure opportunistically will not work, and that's something we'll discuss later, but there certainly have been situations in the case law where there may have been non-performance or a delay in performance before there was ever a natural disaster or any act of God that would have delayed performance otherwise, such that the clause could be invoked.
Yep, and I'll say that one of the things that we can keep in mind is when we're suggesting to be sort of proactive and early about this, it's partly because of this very reason. If you're documenting now, if you're taking a look at your contracts now, you'll be out ahead of sort of those, arguments from the other side in your contracts that come up when somebody says that disruptions that occurred weren't really due to, say, COVID-19 or weren't really the reason why you are now claiming that force majeure.
The next tip would be to monitor relevant government and regulatory announcements, notices, and policies. And that goes for not only import-export related policies, but also just general government closings and things of that nature, and how that may impact your supply chain and your workforce and those of your partners. Also, at the outset, and even now, it's best to look at what would be the best governing law for your contract or your contract negotiations or renegotiations moving forward in the face of COVID-19 and the continued outbreak.
And I'll say as well on that one that it's not only sort of what the best law is, but making sure that your contracts are consistent. If you've got both upstream and downstream contracts and they have different provisions, different law that applies or different force majeure provisions in them, you may wind up in a pickle where somebody can cancel on you, but you can't cancel on the person that's downstream from you.
And along with that, it's important to proactively negotiate with the other party to reach an agreement on possible waivers, ways to substitute performance, and extensions such that you can reach an agreement rather than having to rely on some of the case law that we're going to discuss moving forward. And as you'll see, showing the court in the event that you have to actually go through with any type of litigation related to your contract clauses, showing the court that you made an effort to substitute performance rather than delay or cancel goes a long way. And then the last note, more than a proactive action step, is really sort of a caution, right? Something to consider and think about. The more indirect the link between the alleged breach and any circumstances surrounding COVID-19, the more likely you're going to have a fight, an unseemly fight over the causation may break. I mean, the thing to really keep in mind, and linking back to number 6, is that if you have a robust system in place to document everything related to performance and potential delay, you'll have a stronger argument moving forward about the direct link between the breach and the circumstances for which you were unable to perform, and avoid that causation fight later on.
Yep, and I'll mention on that one as well. Obviously, you heard at the outset that Shevon and I are both litigators, but I think especially with regard to number 11 and number 12, that we really are viewing this from the standpoint not of litigation, but of being prepared to avoid those disputes if we can help it, to be actively negotiating with folks, raising issues with folks in advance. Obviously, if you wound up in litigation over a force majeure in a unique circumstance like this, you're going to wind up with a resolution, say, 12 or 14 months from now, which is not what anybody is looking for or talking about. So the more we can do to be being proactive about getting resolution and getting out in front of things, the better off we are.
So now that we've started at the end, we'll go back to the beginning and really discuss what is force majeure. Typically, it refers to a contract clause excusing performance based upon circumstances beyond the party's control. The reason why it's in quotations is because courts often will use the term to refer to any of about half a dozen laws or doctrines that might excuse a party's performance under a contract. So please be mindful as you review case law moving forward with this presentation that courts usually will use the term interchangeably for a number of different doctrines and laws, but generally it's about excusing performance under the contract. So some of the sources for force majeure in the larger context, there are contract provisions, statutory rights, such as those under the UCC and contracts for the International Sale of Goods, Article 79. There are also common law doctrines that I'm sure some of you would like to forget from law school, but impossibility, commercial impracticability, frustration of purpose, and there are also other phrasings and such as mutual mistake and change of circumstance that are common law doctrines that we'll cover. In addition, going back to the China Council for the Promotion of International Trade and their force majeure certificate.
All right, so we'd like you to keep in mind a couple of things as we're going about the presentation today. First of all, that we do recognize, of course, that certain industries have quite specific and typical force majeure provisions or well-developed case law specific to that industry about those force majeure provisions, whether it be energy or construction or those sorts of things. And what we are trying to do today is make sure that we're covering a generally applicable set of guidelines for folks to get them thinking about this and more knowledgeable about this. The force majeure clauses, of course, can vary from very general boilerplate provisions that nobody ever reads to very detailed and long lists of examples of force majeure. And we'll take a quick look here now at each of those. We've got here actually a pretty common version of a general force majeure contract that you can see. You know, neither party shall be liable for any failure or delay in performance under this agreement for causes beyond the party's reasonable control or occurring without that party's fault or negligence, including but not limited to acts of God, acts of government, flood, fire, civil unrest, acts of terror, strikes, other labor problems. And it goes on, of course, and so people are pretty familiar with this one. It's not super specific, but it does cover the ground fairly well.
And so
right, so I think we're going to... Go ahead.
I was going to say we're about to have our first polling question, but before we move on to that, I just want to give everyone an opportunity to look at this general provision again because the polling questions will be based on this provision.
All right, so if you've all memorized it, we'll give you the first poll.
And so the first question is asking if that provision will excuse a COVID-19 related disruption.
And the
so
idea here, folks, is that if you just click yes or no and submit that, that we'll use that as a basis to talk further. We'll give you about 10 seconds to do that and move on. All right, so we've got about, results are still coming in, but we've got about 65% saying yes, that's going to be enough, and about 35% roughly saying that that might not be enough.
So the answer that many of you, especially in-house counsel, hate, which is that it's going to depend, but based on what we know now, it's far from certain that this provision will protect you in the event of a COVID-19 related performance delay. And as we move forward, I'd like you to look at it again and think about what issues arise related to a potential disruption based on this provision. If there are anything that you see that causes concern for you. And the next polling question based on that will have a couple of answers, and I think we'll move on so that you can see what the choices are. Again, what issues arise related to a COVID-19 disruption based on that provision that you just read? The first is time frame of performance, labor problems, fault or negligence, and the last is all of the above.
So anytime there's an all, anytime there's an all of the above, everybody knows right away it's all of the above. All right, so that's right. A 90% saying all of the above. That actually is the correct answer for this one. We're going to walk through just a couple of pieces of this type of thing to sort of get people warmed up to what issues may arise as we're taking a look at a COVID-19 related disruption and what might happen. So what if the disruption is based upon illnesses or perceived risk by your own employees? We've got this clause that we've highlighted here, of course, that says, there's a whole list of things like civil unrest and strikes, but then it does say here other labor problems other than those involving the party's own employees. And so it does at least beg a question when you've got a clause like this, whether or not you may wind up inadvertently excluding the types of issues that might come up when your workforce is ill. So it's something to be keeping an eye on in your own provisions as to whether or not you've got this type of provision here. Another possibility for a concern here is just who gets to determine the dates that are affected by this type of force majeure clause, right? It says at the bottom here that dates by which performance obligations are scheduled to be met will be extended for a period of time equal to the time lost. And the question may be, at what point are we going to be drawing that bright line of what was lost and how long was it lost? So that may be something to be keeping in mind, and one of the reasons that Shevon and I are suggesting that you make sure that you're documenting right from the start. The other issue, and this one may be a little less intuitive, but we're going to raise it here for a moment, is it necessarily clear that there's not going to be an allegation that the party is at fault or is negligent in creating a part of that disruption? The issue here really relates to, as COVID-19 becomes more known, and of course as various, whether it's the CDC or other entities, are suggesting ways in which to combat the spread of it, whether or not at some point there'll be a question about whether or not the parties could or should have been avoiding some of the results of the COVID-19 outbreak should one occur relating to your business.
So common specific force majeure provisions can be pages and pages long. There are some that are 3-4 pages long specifically on this topic. And here are a number of items that can be included, especially if you're taking the approach of a longer contract provision, everything from specific trigger language to oral and written notice requirements, perhaps modified payment terms or time periods on or after which the original term applied. Generally, though, longer is not necessarily better when it comes to force majeure provisions, because there are, in fact, issues that can arise when there's a more detailed, longer contract provision related to force majeure. And so courts, here are some of the issues that may arise if you opt for a longer, more substantive and detailed force majeure provision. Courts tend to apply the maxim, and I'm probably going to butcher this, ejusdem generis. I think I deserve an extra cookie after this for that. Basically that sometimes even where the list expressly says included, not limited to, the court tends to follow that expressly. Time periods may be very hard to determine, even when there is a particularly detailed provision. Oral and written notice procedures tend to operate as forfeiture provisions. So that's something that I think many of us that deal with contract provisions routinely know that based on the case law, the oral and written notice procedures can operate in that way. And then finally, that the provisions risk superseding common law remedies, which is certainly a concern.
Yeah, and I'll chime in on that because I've been taking a look at some of the case law on this very issue. As we look at the difference between contract rights expressly spelled out in a provision and then tort remedies or common law remedies that may exist in order to get out of a contract, frankly, sometimes those common law remedies are broader than the contract, and it'll beg that question whether or not the contract actually precludes use of common law remedies. And the courts do from time to time decide that those common law remedies are excluded the more specific those force majeure provisions are. So we'll take a look a little bit about some of the opportunities for common law exclusions from performance of contracts and whether or not your detailed force majeure clause is the best way to go. As you're taking a look at these, I will just say that obviously if you were writing force majeure clauses right now, you have a different task than if you're reviewing your force majeure clauses. Overall, the guidance from this type of concern about detailed provisions is just to make sure that you feel like you can either see that it exists in the express terms or that at least it is of the same class or nature as the types of things that are detailed in the express force majeure clause you have. Okay, before we move on to some other issues, I do want to just mention that there are some other things. You know, when we talk about force majeure, we're usually sort of looking for that heading in the contract that says, you know, item 10, force majeure. But of course, other contract provisions can relate to force majeure issues. You can have cancellation or termination or various delay provisions that incorporate concepts like act of God concepts or other unforeseen circumstances concepts. So do make sure that you're also taking a look at those cancellation provisions or termination provisions as well. The other place you might want to be looking in your contract is to see whether or not that contract has an exclusive remedies language in it. Obviously, if there's exclusive remedies language and there's also express remedies for how you would cancel or avoid performance, you may have a different contract interpretation than if you're in a spot where you have a contract and it says that the remedies listed are not exclusive and that you may rely on other remedies as well. All right, so we've got a couple of, and we'll do this periodically throughout the presentation here. We're going to circle back to some of those practice tips that we've been raising. And obviously what that means is with all of the various issues that go into even boilerplate force majeure clauses, we do recommend taking a look at those clauses right now and doing that both upstream and downstream. And that's items 1 and 2, as you heard us say.
And for item 3, one thing to note, and we have not gone into detail later on in the case studies about this, but oftentimes you'll see language that relates to disease, epidemic, or act of God. There has been a lot of back and forth about whether or not act of God is sufficient. So consider your jurisdiction or call someone like us to consider your jurisdiction to determine what specific language is favored.
Okay, so the next question that we're going to address a little bit here really relates more to, all right, so what if my contract doesn't have a force majeure clause? What other places can I go to look for my rights? And so the first of them is in a sale of goods context. We're just going to mention the UCC for a moment here. We've got UCC 2615, or your state's codification of 615, and that gives you an opportunity to claim, or it gives your counterparty an opportunity to claim that there would be an excuse for failure of presupposed conditions. And I won't read all of that language to you, but what it really depends upon is whether or not the COVID-19 outbreak somehow eliminates a basic assumption on which the contract was made. You know, it's an easy enough question if the basic assumption is something simple like I expected I was going to get the parts that I needed to build the good, and I did not get those, right? The other issue is that it would be impracticable. And impracticable in this context is going to mean that it can't be done or that it's exceedingly expensive to do, but it's not just a matter of degree. It's going to be more a matter of kind in this instance. You will see that the UCC also has some additional language about whether foreign or domestic governmental authorities have issued regulations or orders, and whether or not those are valid orders or not doesn't matter if they are in the way of contract performance and you can't substitute performance around them. You have an opportunity to claim a force majeure based upon 2619. I do want to make, or 615, pardon me. And I do also want to make a note, by the way, that notification is required by the express terms of 2615. Okay, another example, by the way, in case you're not doing sale of goods under the UCC, but you have other goods sales, maybe internationally, there are other provisions that are very similar. Article 79 of the contracts for the international sale of goods has an excuse of performance provision as well. It phrases it as whether there's an impediment beyond the party's control. And again, it does have a bit of making sure that it isn't something that was contracted for at the time of contracting by saying that the parties could not reasonably expected to have taken it into account. So as we move forward in this world with the coronavirus spreading, do keep in mind that what is true today may not be true into the future. As we get more information or there are further outbreaks, it may be that the contracts that are made tomorrow are already presumed to be taking into account those types of risks presented by the coronavirus, where contracts existing today may not be. So it's particularly important as you continue to do your businesses to be thinking about what you want your current and now contracts you're entering into after today to be saying. Again, under the Article 79, notice is required.
And looping back to the practice tips, I am happy to sound like a broken record and say notice, 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 underscoring notice. As Dan said earlier, drafting notice letters now, even if you don't plan on sending them, helps you focus on what provisions might be problematic for you and your particular business needs. But it's worth noting that prompt notice is critical even if your force majeure clause does not have a notice provision, and that courts will look favorably on you having informed the other party of potential delays promptly, even if it was not required under the contract.
And then also, we've noted here that you should consider amending your current contracts with explicit language about things like epidemic or pandemic, and that you might even put specific triggering events into them. So you have more of a bright line rule as to when they might be triggered depending on what labor disruption occurs or what supply chain disruption occurs. Even if you're not amending contracts, I would say it's a good idea to be thinking about where you as a business would be drawing your bright line rules about when you feel like you're triggered into needing to take action about force majeure issues if you do need to take that action, so that you're not sort of trying to decide that, at the moment it's happening, you've got a plan in place. All right, so we're going to go into a little bit of law school mode for just half a minute to remember a couple of other doctrines, but we're going to do them pretty quickly here, if folks don't mind. We're going to start with just impossibility and practicability. There are two common law doctrines that are very closely related, and actually some courts and authorities treat them together. But what's best to remember is that there are very narrow excuses from performance. Commentators make clear that it's a very strict standard, and they're not available, as we've been talking about, when the party to a contract assumes that risk. If you, in fact, know that the coronavirus is a risk in a contract you're entering into now, it may be that you don't have this as an opportunity. All right, so impossibility, some cases of impossibility are easy because you have a superseding circumstance and it makes performance objectively impossible, right? The obvious example where the labor is simply not there to provide the service, or the good simply hasn't been delivered in order to be put to its use. In other cases, impracticability exists where there's an extreme, unreasonable, and unforeseeable hardship due to an unavoidable event or occurrence. This is going to be something that it really does need to be extreme or unreasonable. And of course, none of us on this call are hoping that there's any more hardship than already exists relating to COVID-19. But I would say that the answer is it's going to take quite a lot in order to say that something is impracticable. As you can see, it takes more than a mere change in difficulty or expense. And this is one of those doctrines that may not be available if you have a force majeure clause already in there, because the court will determine that in fact you've already allocated the risk and that you don't need the impracticability defense. And then one other thing that is an issue in the case law on this issue is substitute performance. Impracticability suggests that it's more expensive and an undue hardship, but if there are ways to get around that hardship by substitute performance, either for you or if a counterparty is claiming that, you're not going to be able to take advantage of an impracticability doctrine.
So the next doctrine that we'll cover quickly is frustration of purpose. And that typically requires a supervening event, a mutual basic purpose of the contract that has been frustrated by that event. The event was unforeseen, and that is not fairly within the risk assumed under the contract when it was negotiated. The event was neither caused by nor within the avoidance or control of the party that's claiming the disruption or delay. And the event renders the value of the performance essentially worthless. The doctrine can create fact issues as to how a party defines basic purpose of the contract after the fact. As the coronavirus grows more infamous, there is an increasing risk that, at least as to new contracts, that the risks are no longer unforeseen. And that really will change possibly day to day. I mean, what we knew a month ago is very different from what we know now, and I suspect will be very different from what we'll learn in the next 2 weeks. So that really is a moving target, and you have to, again, I think one of the best practice tips is to document so that you can have a paper trail as to what information was available for you at the time and how you made your business decisions accordingly. Again, as the outbreak continues to spread, or even moving forward to other similar outbreaks that may occur in the future, the more that's known, the steps to mitigate its spread and to mitigate your risk really is important that you start to look at that, because moving forward, the issue of whether or not you had control or whether or not you were able to avoid the delay or the performance failure really will depend on what is known at the time.
All right, it's for those reasons that, of course, we've been saying right from the get-go, you're going to want to keep really centralized records for this in terms of all of the ways in which you are impacted, and frankly, if the other side is claiming force majeure, all the ways in which they may or may not have been impacted as they're going. All right, we're going to switch gears a little bit now to talk a little bit more about some China-specific issues that Shevon's going to fill us in on.
As I mentioned briefly earlier, the China Council for the Promotion of International Trade, CCPIT, is a national foreign trade and investment promotion agency. They were founded in 1952, and they fulfill a number of services and roles related to international trade. The most recent and most relevant for our purposes is that on January 30th of this year, they announced that they would offer a force majeure certificate to Chinese companies struggling to cope with the impact of the coronavirus. And so I'll go into a little bit more detail about how you go about getting a certificate and whether or not our certificate is applicable to you, but just to highlight at the outset that if you have upstream or downstream partners or contracts or entities in China based on Chinese law, this is very relevant to you at the moment. So after this announcement on January 30th, on February 2nd, CCPIT issued its first certificate, and that was to an auto parts manufacturer, and that was within 1 day of its application. I think there was a lot of concern or hesitation about how quickly CCPIT would be able to turn around these certificates and whether or not there would be a lot of red tape. But by February 14th, it had issued already 1,600 certificates, and by February 21st, it had issued 3,325 certificates, covering contracts worth a combined $38 billion. So unlike a lot of the red tape that we see when we work with various governments and regulatory agencies, and even our own government and regulatory agencies, CCPIT is really charging forward with going through these applications as quickly as possible and issuing certificates if you have all of the requisite information. So just briefly, a primer on force majeure under Chinese law. I have listed on the slides for you and on your takeouts the articles specifically that address force majeure in China. There are a couple of provisions. Some of them are redundant in that they give an extra backstop to additional language. But for example, Article 94 says that a party may terminate if the purpose of the contract is rendered impossible, right? Basically force majeure. 96 says that you have to have notice. If the contract is terminated, notice is required, or if you assume that you may have to delay or interrupt performance, notice is required, and if the other party doesn't agree, then you have to go to court or arbitration. Article 117 outlines basically that if a party delays and the event happens after the delayed performance, you can't be exempted from liability. And 118 outlines that when a party is unable to perform, they shall notify the other party promptly to reduce potential losses caused to the other party. And again, then it lists the certificate that you can apply for. Again, can't say it enough, can't underscore it enough that it's important to document, and the documentation is particularly important in this context because one of the things you should be documenting is your efforts to reduce potential losses, or if you're on the other side of the coin, documenting the other party's lack of effort to reduce potential losses. Article 180 of the general provisions of civil law and Articles 107 and 153 of the general principles of civil law and provisions of civil law, each of those three basically reiterate what is outlined in Articles 94, 96, 117, and 118 of the contract law. So moving on to what it takes to obtain this force majeure certificate, especially now under this new procedure, there is an online portal by which companies can upload all of these documents and fill out your application. The documents that are required are export, sales contracts, things of that nature, agreements related to customs declarations and freight, shipping, cargo, import, export. Also is required certificates and announcements issued by any governments or institutions that may have impacted your ability to perform, notices or certificates about the delay of cancellation, or the delay or cancellation. CCPIT will also accept electronic order forms or emails in the event that there's no written contract, and it appears that that is a provision or an opening that a lot of companies in China in particular right now are using when there's no written contract. So some things to note about this website and this online portal. The website is completely in Chinese. I have lost most of my Chinese from undergrad and high school. I can order you a great meal and get you some directions, but not able to delve into a lot of the legal Chinese language on the website. One of the wonderful things about Dorsey and our footprint is that we have had offices in Asia for decades. We have staff, attorneys on the ground, both in Asia and here in the U.S., that are able to help you navigate websites such as this, but also the process. and really we're able to partner uniquely across borders to be able to provide our clients with not only the most effective guidance on this particular issue, but the most efficient, because we don't need to go and find local counsel, and our folks on the ground, partnered with folks like Dan and I, are able to help navigate that for you. One thing I will also note about the website is that they have a really wonderful frequently asked questions section that's a great primer on this process and what to expect. Whether you are thinking that you may need to apply for one of these certificates, either because you have an entity there or you have contracts under Chinese law, or you think that you may be the recipient of a notice and recipient of a certificate because you have an upstream or downstream partner in China, looking at the frequently asked questions is certainly worth the time. And to the extent that you don't have someone in your office that's able to translate for you, please reach out to Dan or I, because we have materials available to translate that for you and give you some additional guidance as you try and understand this new process. And then again, looping back to applying practice tips for this, even though CCPIT issues these certificates, I want to make clear that it is by no means a silver bullet. The sufficiency of these certificates have not yet been tested in court in China. In particular, Chinese courts, when examining contract disruption or failure, will look at the more recent statutory provisions and the Supreme Court's interpretation of those things. Another reason why it's extremely important to have someone on the ground that can help you with this, rather than assuming that the certificate is all you need. You also need to be aware of other factors that the court might consider, because this area in particular is in flux. Also, having noted that CCPIT itself has said that a certificate is not sufficient to completely bar liability. So it remains to be seen how effective this will be used in the event that there is a dispute. But what is not up for debate is that many companies in China are taking advantage of this right now, just by the numbers that have been published in the last couple of weeks.
All right, so now we're going to switch gears again a little bit. We're going to work a little bit on some case studies, and it's just an opportunity for us, now that you've heard that background and sort of the way force majeure might apply or other doctrines might apply, to use some existing cases, either about contagions or about labor shortages, to take a look at what courts have actually done in this area on force majeure. The first one we're going to look at actually is going to be a pretty easy one, or at least it seems to be, because all the parties agreed in the first place that the force majeure was triggered. All right, now back to our case study. This case is SNB Farms versus Swift. It's from the Northern District of Iowa in 2003. It relates to hog farmers, and there were 3 of them altogether who had been producing hogs. They had an outbreak of PRRS, which, if you're inclined toward agricultural things like me, is porcine reproductive and respiratory syndrome. And they were not able to be delivering all the hogs they wanted to deliver because they had been afflicted by the outbreak. There were some low prices that prompted the folks they were supposed to be delivering to, Swift, to attempt to renegotiate the contract. And when SNB refused to do that, Swift went a different route and decided that they wanted to terminate the contract based upon the failures that SNB and its 2 other hog producers had done. So SNB claimed to be excused for the underperformance by force majeure relating to the viral outbreak. All right, so we know that the contract contained a force majeure clause, and all parties agreed that the PRRS outbreak constituted force majeure. The issue that wound up occurring in the case was that Swift, the company that was supposed to take the hogs, had actual knowledge of the PRRS outbreak as it related to this SNB Farms, but the other 2 hog producers had not actually complied with the notice provisions for force majeure. All right, so we're going to have a quick little poll here for those of you who are still paying attention. The question is, are Swift and the other growers allowed to force majeure? And a little yes or no real quick from folks. All right, so we've got about a 60-40 split on that. And the short answer is that what actually happened is that the two hog producers who had not given notice forfeited their rights to claim force majeure, even though there had been actual knowledge on the part of the receiving company in the first place. So it's just one of those, if you're taking a look at court cases, it is just one of those examples where a seemingly maybe unjust result occurs because the court is going to follow that contract. I will note that as we look at the practice tips that one of the issues around a potential COVID-19 outbreak, it might or it might not make it difficult to identify that moment of force majeure, and that's why we suggested that having that opportunity to look in advance at what circumstances might trigger your need to declare a force majeure is probably a thing to do well in advance of the problem.
Next, moving on to something that is relevant to all of us now, given a lot of the closures, is that what happens if there is an unexpected governmental action? That could be something related to the import-export regulations, or when a government shuts its doors, or mostly shuts its doors. And in looking at that, one case that provides some information about how this type of situation might be handled is the Macromex v. GlobalX case. GlobalX was a food product supplier. It contracted to sell Macromex 112 containers of chicken parts, and it was going to be delivered in Romania. And before delivery, but after shipment had been due, Romania declared that no uncertified chickens could be imported into Romania. And that was without notice to the parties. But again, it was after shipment had been due. GlobalX failed to make the deliveries and claimed to be excused because of Romania's unexpected regulation. Macromex sued for $600,000 in attorney's fees. The contract in this case was governed by the Contracts for International Sale of Goods, which contains the force majeure principles that we discussed earlier. And so the question for the audience is, was GlobalX's failure excused because of Romania's actions? And so, and I'm not sure what the results were. If Dan wants to.
Yep, sure. We're showing about a 60-40 split between no, they were not excused, and about 40% saying yes, they were excused.
And so the court in this particular scenario found that they were not excused. And part of that was related to the fact that the court found that there were other ways by which that GlobalX could have made the deliveries and could have had substitute performance by shipping out through other means. Not only that, before the shipment had been due, they had already blown past the deadline. But I'm sorry, before the force majeure issue, meaning Romania unexpectedly closing down the import of uncertified chickens. Before that even occurred, the GlobalX had already missed shipment dates. So those two factors together, the court found that GlobalX was not excused based on Romania's regulatory actions.
So we think that there's a couple of takeaways that we can take from a case like Macromex as well. And one is just a really simple pragmatic advice that I know everyone on this call works very hard at making sure that they're always contract compliant. this is a time period in which it's going to be doubly important to be making sure that we're really strictly applying the contracts that we have so that we don't wind up in a situation in which, inadvertently something which might be typically excused otherwise winds up being a part of the problem if we do wind up in a setting where one party or the other needs to claim a force majeure or a related doctrine. And then, of course, as we've noted, make sure that you're continuing to monitor government and regulatory announcements so that at the moment things happen, you're able to respond to those.
And as a refresher of what we stated earlier, really look at your various provisions in your contracts, both upstream and downstream, to determine if there are any conflicting law provisions between your upstream and downstream, and really look at, as you negotiate and renegotiate, what the best governing law is for you and your business needs based on what your concerns are with that particular partner.
Okay.
And then also
go ahead, please. Yep.
Yeah, and then also, as we stated earlier, negotiating with the other party in advance, being proactive, because courts will work to find a manner of substitute performance that could have sufficed. So in the case that we were just talking about with the chickens going to Romania, the court determined that there were other avenues of transport to fulfill performance. So you really have to look at what the options might be and attempt at least to negotiate with the other party to find ways to substitute that.
All right, so you may have noticed that an awful lot of the cases involving contagions relate to things like food production or agricultural issues, and this next case is going to be no different, but we're going to address one that relates to supply interruptions and the downstream effects of those supply interruptions and what happens when causation becomes a little bit unclear. All right, so this case is Rembrandt versus Dames Stainless. And this is an egg producer that was planning an expansion project, and they ordered an egg dryer from Dames Stainless. And they wanted to put that in a new facility. And then unfortunately, the egg producer suffered an avian flu outbreak a couple of years ago in 2017, is when the case is from. And it caused about 1 million hens to be destroyed, and it caused about a 50% reduction in egg production. So Rembrandt lost a lucrative contract because of the decreased capacity, and they canceled the expansion because they didn't need the expansion anymore, and provided notice that Rembrandt was excused from buying the dryer. All right, so the question for everyone is, does this scenario sound like a good candidate for force majeure? All right, so we see the results here in this one is 54-45. It's a very close one, and there's going to be a reason for that in just a moment as well. But it prompts me for a moment just to say that I know that all the folks on this call, very smart folks, and people have different reactions to these things, which means that there isn't always a lot of clarity, and judges will have the same types of, 50-40, 50-50, 60-40 splits. And so it is important to be doing that negotiation in advance. What actually happened in the Rembrandt case is another lesson in sort of what it means to get into litigation, because what actually happened was, in that particular case, the force majeure clause was inadvertently one-sided. It referred to only the work being done, and it didn't give both parties the opportunity for force majeure. The court was undaunted, though. They applied those frustration of purpose principles in the common law, and actually wound up deciding that absolutely every issue on frustration of purpose resulted in a fact issue requiring a jury trial. So there was a dispute about whether or not the principal purpose was frustrated. There was a dispute about whether or not there was causation or whether Rembrandt could have helped to avoid the avian flu outbreak. And there was even a question about whether or not that was a basic assumption of the contract that Rembrandt would be doing its expansion when it was trying to buy that dryer. So Obviously, as we all know, litigation is not always the ideal place to be, and so anything you can do to be avoiding those instances probably makes some sense. Okay, what can we learn? That the more indirect the link between the problem that you've suffered and the circumstances saying that you can no longer perform, the harder it is going to be to get a quick and easy result. And frankly, as we've seen, the harder it is to agree on what that result should be.
So I know we're pressed for time, so we're going to go through the next couple of slides very quickly, and we appreciate you guys sticking with us. The next two cases address labor shortages, Canfor versus Packard Square. Briefly, Packard Square failed to substantially complete a construction project. They asserted two events, an electrician strike and a labor shortage. The contract did have a notice provision for force majeure, required notice within 2 days, and that was late. Ultimately, the plaintiff argued that the strike could not have been the cause of the delay based on where the project was, what phase the project was in when the strike occurred. And Packard Square didn't have any evidence, again, going back to keeping records, to dispute that assertion. So the performance delay was not excused. Another case out of the 10th Circuit, Aquila versus CW Mining, is a public utility company versus a coal mining company. The coal mining company asserted force majeure based on what was some geological problems, but also related to a labor dispute and resulting labor shortage. When the public utility company ultimately got the rest of the coal that was required in the contract from another source, CW Mining up and canceled the contract entirely. Ultimately, the 10th Circuit decided that acceptance, as I skipped over that bullet point, but the plaintiff did accept partial delivery of the coal. The 10th Circuit found that acceptance of delivery did not amount to waiver, and that the mining company didn't give sufficient notice, and so they were not excused based on force majeure. And then wrapping up, the last tip is, again, keeping detailed, centralized records, as we've mentioned several times. I think, Dan?
I'm sorry, it sounds like maybe not everyone could hear me, so I will make sure that everyone can. We're going to do one more case study on decreased demand, and the question will be whether or not depressed demand is a force majeure, whether or not COVID-19 would be an unforeseen contingency, and what we're going to do ongoing with our contract negotiations. All right, so the case really quickly is Wrexham versus Rembrandt. That's the same issue that we had previously with Rembrandt, but now they've got a different problem. They're on the other side of it, and Wrexham has agreed to buy their eggs, and Rembrandt suffers a bacterial outbreak, and Wrexham at the same time has its buyers unexpectedly falling through. Ironically, it's actually Wrexham that claims the force majeure, not Rembrandt. Wrexham decides that it wants to say that the cage-free business isn't what we were told it was going to be this time of year. So they're suffering that demand fault, and so they're hoping maybe to get out of that contract. What actually happens in the case is that there is a force majeure clause, and they argued frustration and commercial impracticability as well. The court denied on every ground with the idea that a mere drop in the market demand is not an excuse, and absent some unforeseen contingency that it alters the essential nature of performance, they weren't going to let Wrexham out of the contract. That seems like a reasonably obvious result, but we use it just to point out that as this process continues and whatever is going to happen with outbreaks into the future here, there may come a moment where there's no longer that unforeseen contingency and that there's no longer that ability to say that people did not realize what was going to happen. In the abstract, demand depression could be a force majeure, but it does need that unforeseen contingency as well. All right, so the last tip on that one is just to make sure that everyone understands there's decades of court cases out there saying you need more than just the market forces dropping in order to claim that force majeure.
And one thing to leave everyone with, food for thought, is the second bullet, that as contracts continue to be negotiated in the months ahead, under what assumptions are they being negotiated, and what is the mutual intent of the parties, now knowing that COVID-19 possesses a risk perhaps to your supply chain or your labor force. The situation, of course, is fluid, and moving forward, the intent when there may be smaller outbreaks as opposed to a larger pandemic may be different, as those scenarios and the implications for your business may be different. But ultimately, one thing to think about is how long is COVID-19 an unexpected contingency? And even moving forward and taking that a step forward, at what point does COVID-19 serve as notice for COVID-23 or the next SARS-related epidemic? And at what point are courts, and this is an open question and we will see, at what point will courts take one scenario and carry it over to the other such that your partner or the other party can claim that the delay or the disruption or the failure was foreseeable based on what had occurred last year or 2 years ago with a related outbreak or a related shortage supply. So all that to be said, that there is quite a lot of fluidity there, but certainly things to think about as you apply your the practice tips that we outlined to your current concerns, not only for this particular virus, but perhaps viruses moving forward.
Okay, so with that, we hope that this has been helpful for folks. We're going to really encourage that folks get very proactive about both what their own contracts and risk situations are, and also with what their ongoing contract negotiation practices are, and make sure that you're as specific as you can be when it relates to the coronavirus as to how your contracts are going to be treated if and as potentially outbreaks do occur to disrupt. We've got a couple of just quick housekeeping items here to make sure we get to folks. We've put the top 12 out already, so we won't go through that again. But I think, Shevon, do we have a couple more things to mention?
Yeah, just briefly, we, of course, want to thank you all for joining us today, and also want to highlight an upcoming webinar on March 26th, Legal Tools for Managing Cross-Border Risk in a COVID-19 World. Our colleagues will, during that webinar, delve even more deeply into some of the issues related to shortages and supply chain in China. Also, we encourage you to reach out to us if you have any questions. You can reach out to us directly. Our emails are obviously on the website, but also at the beginning of the PowerPoint presentation. Also, you can email questions directly to dorseyu@dorsey.com. I hope that some of you were doing that during the presentation, but we will follow up with you as quickly as possible if you have any questions related to this webinar or how we may be able to help you moving forward as you look at your contracts and decide what avenues your business needs to investigate as they move forward in this environment.
With that, thank you so much to everyone for joining us, and thank you to Shevon for helping us out today as well.
That does conclude the webinar for today. We thank you for your participation and ask that you please disconnect your line.